time allocated.
All right.
My lady, my lords, permit me to join issues with the earlier submissions made by my learned friends, and permit me, my ladies, my lords, to submit that my submissions will majorly deal.
Can you join issues on the same side? Join issues? We haven't submitted.
What problem do you have with that, Professor Gender?
My lord, join issues means he's on the opposing side, but he's supporting the applications as framed. So I don't know whether it is simply a question of not knowing that we haven't spoken, perhaps. He's running low on sugar.
My lord, the presiding judge, you made an important point that we are Africans.
I think let Njiru proceed.
And he will have his time to speak the right English when his time comes. My ladies, my lords, my submissions will deal with the aspects of public interest in respect to the reason why the court must sustain the conservatory orders as granted by his Justice Mongo and Justice Mwita. Your Lordship, permit me to begin by drawing your attention to the dictates of Article 3, which requires every person to uphold and protect the Constitution from being violated. My lady, my lords, the Constitution that we are here to protect this afternoon is a document that is progressive in nature and that seeks to protect individuals who either serves in government or out government in whatsoever organ. My lords, in my address, I'll majorly deal with the question of the purported nomination of Professor Kindiki and whether the lifting of the conservatory orders will culminate into his swearing in and what that means in respect to the provisions of the Constitution. My ladies, my lord, it is clear that a purported process took place in Parliament that culminated into a name being forwarded to Parliament for voting. My ladies, my lords, it is important for us to interrogate the circumstances that led to the forwarding of this name, and whether or not that process is confirmed with the dictates of the Constitution. My ladies, my lords, on the 18th of October, we worked to what my learned friend Mr. Ongoya submitted on a memorandum by the President. The said memorandum, my ladies, my lords, indicates that the President sought approval and confirmation from the Independent Electoral and Boundary Commission. And the answer that he got was sufficient enough to afford him the courage to forward the name for voting in Parliament. But the question, my ladies, my lords, that begs an answer is, did the IBC possess the requisite constitutional capacity to submit or approve the said name for purposes of voting in Parliament? My ladies, my lords, the answer to that will be found in Article 88, as read together with Article 99 and Article 137 of the Constitution. Article 88, my ladies, my lords, creates the Electoral and Boundary Commission. And in the same article, my ladies, my lords, creates the functions of the said commission. You'll also find the same answer, my ladies, my lords, in the amended IBC Act. Most importantly, Section 10 and Section 11, which I'll be dealing with in the near future. My ladies, my lords, Article 99, as read together with Article 137, provides the qualifications for an individual to hold the office of the President and by extension, the office of the Deputy President. It is important to note, my ladies, my lords, that in the event anything happens and the current president is incapable of executing the functions of office of the president, the purported name, if sworn in, will be the person to take over. But will he have met the necessary requisite qualifications? And who is mandated to ensure that these qualifications are met? We submit, my ladies, my lords, that the only constitutional organ capable of executing that functions is the Independent Electoral and Boundary Commission. The court will take judicial notice, my ladies, my lord, that the commission as currently constituted falls lack of the commissioners. And the question therefore, my ladies, my lords, in the event the commission is called upon to evaluate the qualifications under Article 99 and Article 139, so that then, my ladies, my lords, a name can be submitted in Parliament for voting, who then is capable of doing that in the absence of the commissioners? My ladies, my lords, we submit that IBC as currently constituted can only execute administrative functions and has no capacity or ability to execute the function under Article 99 as read together with Article 137 of the Constitution. My ladies, my lords, the Constitution as read together with the IBC Act has created distinct functions that for the commissioners and the secretariat. And you'll find that, my ladies, my lords, in the decision, consolidated petition number 305, which was between Engineer Mwaura Kamau, Charity Kilukaluki Ngilu versus EACC. A three-page judge, my ladies, my lords, had that to consider whether the secretariat, in the absence of the commissioners, can take the functions designated and exclusively allocated to the commissioners. My ladies, my lords, at paragraph 347, this is what the court had to say. From the foregoing provisions, it is clear to us beyond peradventure that the membership of the Constitutional Commission is between 3 and 9 members. In other words, the composition of the Constitutional Commission ought not to be less than 3 and not more than 9. The court goes on to say that if the secretariat, and in this case, the CEO to the IBC, would then be seen to execute the functions of the commission, it would then mean that the commissions would go beyond the constitutional dictated number of either 3 or 9. The court said at paragraph 348, the said members, otherwise known as the commissioners, are empowered to appoint the commission's chief executive, known as the secretary. To contend that the secretary, who is an appointee of the commission, is part of the commission would mean that the commission would, where commissioners are 9, be composed of membership of 10. The court said one only needs to mention this to realize how ridiculous this argument is. It is therefore our submissions, my ladies, my lords, that the name that was submitted to Parliament is not capable of replacing, in the event this court dismisses our petition and upholds the impeachment, the Deputy President of the Republic of Kenya. The court further said at paragraph 353, I refer the court to have a look at paragraph 353 and paragraph 354. But of the most importance is what the court said relied in the case of petition number 46 of 201. The court relied in a Ugandan case, and this is what the court said. It is clear to us that under the Constitution and under the legislations, the foundation of the power of a secretariat is the existence of the commission. A secretary and the secretariat can only carry out the powers vested in their offices when the commission is in place, exercising its powers since they implement what the commission has approved or resolved. Again, I urge the court to look at paragraph 356 and also 358. But most importantly, your Lord, my ladies, my lord, is what the court is saying at paragraph 362. This is what the court had to say. We therefore also agree with the petitioners that any decisions purportedly transmitted to the DPP recommending the prosecution of the petitioners without the sanction of the commission would not be in compliance with the law and the constitution. We urge you, my ladies, my lords, to find that the name that was submitted in parliament is not capable of replacing the deputy president of the Republic of Kenya. Why is that important, my ladies, my lords? Because if the orders are lifted today, that will be the next course of action.
My lord, that's not a finding you can make in your ruling on an interlocutory application.
Why, my ladies, my lords? Because this is a train with many compartments and many stopovers. The next stopover that we shall land on, my ladies, my lords, if the orders are lifted, is to have a person who was not duly appointed in accordance with the Constitution taking over the office of the Deputy President. My ladies, my lords, permit me to draw your attention to paragraph 365, 336, and 337 of the same judgment. And this will be my final submissions in respect to this judgment. At paragraph 367, the court is saying, whereas a commission may be disabled in its ability to perform its functions, such disability does not automatically render the commission extinct. Such an event, in our view, only places the commission in a state of dormancy until such a time as it is able to carry out its functions. My ladies, my lords, I have perused the replying affidavit filed by Marjan on behalf of the IBC. He makes no reference to the memorandum filed by the president. My ladies, my lords, he technically makes sure that he does not make reference to that so that he may not be seen as if he has delved into the functions of another organ. My ladies, my lords, permit me to draw your attentions to section 6 of the appointment point. I beg your pardon. Paragraph 6 of public appointment parliamentary approvals. And as you look at paragraph 6, also look at the definitions contained at paragraph 2 of the same act. What an appointment means and what a candidate means. And for avoidance of doubt, a candidate means a person who has been proposed or nominated for appointment to a public office. Section 6 creates the criteria upon which Parliament must follow so as to satisfy the need for public participation. It also creates the time within which this must be executed. It has been submitted that this was executed in a supersonic speed that took approximately 6 hours, and the Republic of Kenya had a new deputy president proposed. But the question, my ladies, my lords, is, can this be done in the absence of the exercise of the sovereignty of the people of Kenya? If we were to allow this, my ladies, my lords, what will be the import and what will be left of Article 1 of the Constitution? Will it be to mean that Article 1 of power belonging to the people will be meaningless? Additionally, my ladies, my lords, what will be left of Article 10 of the Constitution that requires state organs to be bound by the provisions of Article 10 whenever any of them executes the functions bestowed by it by the law? My ladies, my lords, the question of public participation, even in the process of the nomination of the said candidate, is paramount. That under Article 118, Parliament is enjoined together with Article 10 to carry out public participation. And that is the only way, my ladies, my lords, that Parliament can be said to have exercised the sovereignty of the people of Kenya through the delegated democracy concept. That is to mean, my ladies, my lords, if we were to sanction whatever happened on the 18th, and allow it to pass, and the conservatory orders are lifted and is sworn in, will have let the people of Kenya down. They will not enjoy the provisions bestowed upon them by Article 10, Article 1, and Article 118. Article 118 creates and dictates that these individuals cannot be left out. Finally, my ladies, my lords, let us look at the question whether we have made out a case that deserves the granting of conservatory orders, and one that also deserves the dismissal of the applications by the respondent. My ladies, my lords, the National Assembly handsets have been brought before you, and I will draw your attention to page 45 of the said handsets. And most importantly is the submissions that were made by Honorable Millie Othiambo, the Member of Parliament of Suba North. At page 48, she makes observation that public participation had only two...
Do you have the Hansard as part of the affidavit?
Yeah, they have been filed.
They have been filed?
Yes, yes, my lady.
Where do we find them?
Is it part of the application? It's part of the petition, my lords. That is 522, the Hansons.
Part of the application or part of the petition?
Petition.
Yes, then that is something different. You are dealing with the application.
But most importantly, my ladies, my lords, it went on Hansons that only 200,000 people purportedly participated in that process. That is to mean, my ladies, my lords, for Honorable Mutuse to have the guts and the audacity to move the motion, he had the backing of 200,000 people as against a population of 50 million Kenyans, or as against the population of over 14 million registered voters. What begs question for determination was that a qualitative and a quantitative public participation? Was it meritocracy? Does it deserve or could it convince that public participation that was adequate was conducted before the motion was moved? My ladies, my lords, to afford us an opportunity to bring this case out, we beseech you, my ladies, my lords, that you sustain and allow the conservatory orders sought and dismiss the application by the respondents. Finally, my ladies, my lords, I invite you to look at the submissions filed by the Attorney General in support of the application. Of most importance, my ladies, my lords, the Attorney General at page 6 of her submissions invites you to look at a conservatory order, sorry, not page 6, my ladies. That is page 5, as one that is meant to maintain the status quo. And she tells you, my ladies, my lords, that the status quo to be preserved is a status quo ante. That is to mean that the status quo that the court needs to preserve is the approval and the voting of Mr. Kindiki. That is, according to her, the status quo that she needs to be preserved. And she makes out a case that the conservatory order needs to be set aside so that that status quo can be sustained. There can never be anything that is far from the truth, my ladies, my lords. The orders of Justice Mwongo stayed each and every aspect that took place, including the implementation of the resolution by Parliament to consider the first petitioner as impeached. She further tells you in her submissions that conservatory orders are only capable of being granted under Article 23 of the Constitution. And she argues that Article 23 only relates to the Bill of Rights. And then she further argues that if the petition is not premised on violation or infringement or denial of a human right, then conservatory orders, according to her, are not capable of being granted by the court. But my ladies, my lords, we have put up a case that a right to a fair hearing was denied. We have put up a case that the Senate of the Republic of Kenya decided to abrogate Article 25 of the Constitution. If that is not a question that relates to a Bill of Rights, what then does it relate to? Further to that, my ladies, my lords, under Article 258 of the Constitution, to which we are saying that the Constitution has been abrogated and violated by the respondents, what remedy can the court issue in the circumstances that a case is brought out that the Constitution has been abrogated and violated by the respondents, if it's not a conservatory order? My ladies, my lords, finally, as I pen off, I invite you to look at the principles of public interest. It is in the public interest, my ladies, my lords, that these orders be sustained so that the Republic of Kenya can have the opportunity of the court pronouncing itself whether their democratically elected deputy president was justifiably removed and lawfully removed from office. That is to mean, your ladies, my lords, that under Article 38 of the Constitution, the people who supported the deputy president have a legitimate expectation. A legitimate expectation that their deputy president, as elected, will be subjected to a proper and accountable and transparent mechanism of removal. They also have a legitimate expectation that if any organ constituted by the Constitution does fail to abide by the dictates of the Constitution, that this court will uphold that position and that this court will set aside the impeachment. And the consequences of that, my ladies, my lords, is that if this court is convinced by our argument to set aside the impeachment, the question will then be that the deputy president will assume office. Number two, my ladies, my lords, you'll be urged to set aside the conservatory orders on the basis that there is constitutional crisis that is looming. But who has precipitated and created this constitutional crisis, if it does exist, if not the respondents? If they followed the law to the letter, and we feel satisfied that our client was justifiably removed from office, we would not be before you, my ladies, my lords. We would have taken an ample pie and go home. But we are here before you, my ladies, my lords, because the situation has been precipitated and created by the respondents. Finally, my ladies, my lords, if the respondents are the ones who are at fault, do they deserve your mercy? What is the position of equity if they come to you with dirty hands? Do they deserve your mercy? He who comes to equity must come with clean hands. They are the transgressors and the violators of the Constitution. And therefore, my ladies, my lords, they cannot come before you as though they are saints. I so urge you, my ladies, my lords, to dismiss that application and uphold the application for the maintenance or for the retaining of the conservatory orders. I am most humbled.
Thank you. You have four.
My Lord, I appear for the 9th petitioner.
You will have 5 minutes.
My Lord, presiding judge, my Lord and my ladies, if it pleases you and in keeping with the notices affixed to the walls of this wall, permit me to reintroduce myself. My name is Wamboi, Shadrach Wamboi. I appear for the 9th petitioner. My Lord, for the purpose of the court record, we equally have a pending application dated the 18th day of October, 2024. And to assist the Honorable Court, we have filed submissions dated the 29th day of October, 2024, and a list of authority dated the even date, the 29th day of October 2024. My Lord, we rise in support of the application as urged by my colleagues and my seniors to confirm the conservatory orders that have since been issued, and in any event, to allow our request to have a suspension of the decision arrived at by the Senate on the 17th day of October 2024. My Lord, we take a very simple approach on the complex matters that lie before you for determination, and the manner in which we look at whether the court should grant or disallow the requests that are prayed is that this honorable court is invited by the Constitution to be imaginative. The grant of orders of conservatory orders require that the court goes over and above probably the circumstances that are drawn that have necessitated the filing of a petition before court, so that the court can either, in the words of Article 22, arrest a threat to the violation of a right or a fundamental freedom. My lords and my lady, doctor, for you to imagine the circumstances that would be if the orders are not confirmed by this honorable court, then, my lords and my lady, you must, and I say this with tremendous respect, reflect on the assumption of the Office of the President Act in order for this honorable court to be alive to the prejudices or the prejudice that the petitioner and the Honorable Deputy President Rigathi Gachagua will face if the orders sought are not confirmed. My lords and my lady, we make the submission that to disallow our application will lead to a wastage of public resources, which this court is joined under Article 201D. My lord, this court is empowered or given the obligation under Article 201D of the Constitution to ensure the prudent and responsible way of the use of public resources. So that, my lady and my lords, the denial of the reliefs that we seek will automatically prompt the swearing in of the person of Professor Kithure Kindiki to assume the office of the Deputy President Rigathi Gachagua. My lady and my lords, pursuant to Section 12 of the assumption of the office of the President, this must be done first within the capital city of the Republic of Kenya, which is in Nairobi, and secondly, on that date when we are supposed to have the swearing in of the Deputy President, must be a public holiday. My lady and my lords, while being treated to a public holiday might not seem to be a bad thing, as it will give the court and councils an opportunity to rest, it's a bad thing, for one, that firstly, Kenyans who live from hand to mouth will have to take a rest. Secondly, at a time when this honorable court is expected to be doing its business, this honorable court will be forced, my lord, to retire and perhaps to add on to the backlog of cases that we face in the Republic of Kenya. So that, my ladies, my lords, as I conclude my very humble submissions, so that I can pave the floor to my senior, is, my lords, you have an opportunity of arresting a situation that will lead to the use of public resources in a public ceremony that may, in the fullness of time, end up be declared as unconstitutional for the very grounds that we will be persuading you when we come to making arguments in support of the petition that lies before court. My lords, that should be all from me. I will pave the floor to my colleague Wanjiku.
Thank you.
Thank you for the 9th petitioner. Thank you.
My Lord, may I just for housekeeping, my Lord. My Lord, is it possible that at least the court is told who appears for who? Because we may have, I do not know how many advocates are supporting. We may sit here to the end of time because each person is taking 5 minutes, and my concern is that the advocates who are appearing for the same client taking 5 minutes each, and then we do not know what we're dealing with, my Lord.
You appear for which party?
For the 9th respondent, for the 9th petitioner, my Lord and my Lady.
The same person?
Yes.
You had 5 minutes to share between the two of you. Mr. Wanjiku, Wamboi has taken more than that.
My Lord, sorry. I don't know, should I go? Because I'm for the 2nd petitioner.
Yes.
My name is Kimoto Teresia Njiru, Makazi, Tess Kimoto and Company Advocates from Kerugoya. And on behalf of the 2nd petitioner, we wish to say that we support the application for conservatory order to remain in force. And the reason why we are saying so is that if you look at our petition, the prayers that we are seeking...
Sorry, my Lord, with your permission, my Lord, with your permission, I'm sorry, because Ms. Kimodo was submitting, and it was our understanding that for the 9th petitioner, because she is not representing the 9th petitioner, it was our understanding that the minutes that were allocated to us, initially, Mr. Shadrach Wamboi has taken, and we were to compress the same so that all parties appearing, because we are 4 of us, were to iron out those issues and submit, because it's only submitted on one point. So that before she submits, we're requesting kindly for accommodation so that we can air 1 or 2 issues that were left out by Shadrach. Because I was to do a minute, and Mr. Omari was to do another minute as we conclude for the 9th petition. We are sorry about that, so that when she takes up, she'll take it up from a standpoint of...
Does it also not bother you that most of the points or the principles you are putting forth have already been put forth even more eloquently and recorded?
My Lord, that much we agree, but there are 1 or 2 issues that were left out. That is why we wanted to seek for your permission so that we can air all those that...
I think we still believe in the old doctrine that a council can stand up and say that I adopt wholly the submissions of a council who has gone before them, because I think these arguments have been put very eloquently and we have recorded them.
Very well, if those be the directions, my Lord...
But I'll give you 2 minutes.
2 minutes.
After Ms. Kimoto has finished.
We are most obliged. We'll share 1 minute each with Mr. Mari. Thank you.
Yes, sir.
People yet to come, including the respondents, I hope you take note of that. There's no need for repetition, absolutely none.
Yes, sir. The reason why we are in support of the conservatory orders remaining in force is that when Justice Richard Mwongo was issuing these orders before Kerugoya Law Courts, he had in mind petition E013 and petition E014. So he knew very well what he was doing, because we appeared before him several times and we tried to stop the impeachment proceedings. However, it was not possible and he consolidated the files. Therefore, if you look at our petition E013, what we are asking for is an apology by the Deputy President of Kenya, Honorable Rigathi Gachagua. So if these conservatory orders are lifted, what are we going to do? Are we not engaging in an academic exercise where our petition has been consolidated, but we are not being given a right to fair hearing, so that the court can understand why we need this apology. And this petition was filed first. It was filed on the 25th September, before the impeachment and after the impeachment. So we are praying that we be given a right to fair hearing. We be heard first. We have nothing against Professor Kindiki. However, once he assumes office, he will now become a deputy president, and therefore we do not need an apology from Kindiki. We need an apology from Rigathi Gachagua. And we need an apology from him when he's at his official residence. No. They will have, no, allow me to.
My Lord, may I just interfere? The petition by Kimotho and company required the deputy president, then, now impeached, to apologize to the National Intelligence Service, NIS, completely overtaken by events. I don't even know why she's here.
No, that is uncalled for, and I hope the bench will protect me.
I think Ms. Kimotho is rightly before the court.
Yes, thank you, Judge, for protecting me, because I almost quoted the paragraph 110 of the disposition of this court, where you assured us that we are going to have a fair hearing. So therefore, thank you, Justice Charo. So what I'm saying is that, yes, so what I am saying is that we need an apology from the Honorable Rigathi Gachagua, him being the Deputy President of Kenya. So what we are saying is that we want him, at least we are going to support even the issues of how he was impeached, so that we can get to the bottom of this. And we still have a chance, because he has not left office. And if he has not left office, then we have a chance to be heard in our petition, E013. So allow us to be heard, so that after we are heard, the court can decide if our petition has merit or not. And that's why we are in support of this. And we do not want a kienyeji apology. Our apology is very clear from our pleadings, because these utterances he made when he was in office, and they carried weight. Why we are insisting is that the NIS team, and especially my client who is affiliated to the NIS, he was affected. In fact, where he stays in Kirinyaga, he cannot stay anymore because of those utterances. No, these issues are in our petition. The respondents have not responded. In fact, our petition is unopposed. So therefore, we are insisting, if at the interim stage, the conservatory orders are lifted, what it means is that we will not have a chance to get what we are praying for in the final stage. So it will be in our view, we will have been overtaken by events at that particular moment. Therefore, when we remove this conservatory order, it only means that we'll have a final order in the interim, because now there will be a new deputy president, and we sued Honorable Rigathi Gachagua when he was the sitting deputy president, as a deputy president, not as Honorable Rigathi Gachagua. So we are praying that the court do look at this. There was also an issue of public participation. Once we were consolidated, those are the issues that are also in petition E014, on how the public participation was conducted, which we, of course, we support. It was hurriedly done. So we did not even have a chance, or many people and many Kenyans did not have a chance to give their views. So again, just 1 minute. Again, this is what we are saying. It will now go to an academic exercise where we just appear before the court and expect just to be told you have no right anymore, and you're overtaken by events, just like some councils were trying to say. That's all. Thank you.
Thank you.
Your Lordship, for that petitioner,
Sorry, my lord, I was to take cue. My name is Sam Nyaberi. You gave indications and directions earlier that we take 2 minutes. I wish to call upon Waithera, who was on her feet before, so that I donate my time to her in the spirit of nurturing young talent, and so that she can also raise a fee note to be paid.
Ms. Waithera, how are you?
I'm fine, thank you, my lord.
You have been donated time, so take it and make your submissions.
Thank you, my senior Mr. Nyaberi. My name is Wanjiko Waithera for the 9th petitioner. And taking off from where my senior Mr. Wamboi left off, I wish to submit on the issue that the respondents raised in their responses, that is separation of powers, in which they are seeking to have the applications dismissed on account that Parliament has the respondents, that is the Senate and the National Assembly, have privileges to conduct their proceedings, and such proceedings must not be challenged in court. And I wish for this court to be guided by the decision of Justice Lenaola in the Commission for Implementation of the Constitution versus the National Assembly of Kenya and 2 others, 2013 EKLR. And I will quote part of the passage where the court said that, to my mind, the separation of powers is not an absolute, to my mind, the separation of power principle contained in the Constitution is not absolute, and the courts, as defenders and protectors of the Constitution, have to be allowed to interfere where there is a violation or threat of violation of the Constitution. The court further went on to say that the primary duty of the court is to the Constitution and to the law, and which must apply impartially and without fear or favor or prejudice. The Constitution requires that the state to respect, protect, and promote and fulfill the Bill of Rights. My lords and my ladies, what is challenged before you are the proceedings that were undertaken at the Senate, and amongst what we are challenging is the right to be heard that was denied to the first petitioner, which forms a cornerstone under Article 47 of the Constitution. And therefore, my lords and my lady, this court stands at crossroads of history with a rare opportunity not to merely interpret the law, but to define it in a way that will, echo through generations. The decisions of these proceedings have the potential to set a benchmark that will solidify principles of accountability and strengthen our democratic foundation. We therefore invite the court to allow our application and issue the conservatory orders as prayed, and in so doing, we will be cementing the constitutional principles of this country. Thank you.
Thank you.
My lord, having had that, we organized Ms. Omari will do a wrap for 30 seconds or 1 minute.
I hope you meant 30 seconds.
My lord, I didn't want to talk, except that to bring to the attention of the court that the public participation was done on Saturday, which is contrary to Article 37. Number 2, the public participation was supposed to be done at the polling station level. Deputy presidents and presidents tallying ends at the polling station. Third, the notice of the constituency public participation. The court gave the orders at around 4:30. There was no notice sufficient for people in the villages to go to the constituencies. Therefore, that completely made people not to participate because they were not aware. The notice that was initially given was a notice at the constituency levels. Can that be the position that this court will uphold? I beg that the court extends the grant of the conservatory orders. Thank you very much, my lords and my lady.
Thank you.
Your Lordship and my lady, my name is Sakimpa. For the third petitioner, we'll be sharing time with my colleague, Mr. Wathuta. Your Lordship, you've already stated that the principles of conservatory orders have been eloquently espoused by my learned seniors, so I'll only put into context in our petition. Your Lordship, in the case of Peter Munya, the issue of inherent case is what I want to address using the ruling that was delivered by Justice Richard Mongo in petition E014. Your Lordship, and this is what the learned judge found upon perusing the documents, that on my motion I had perused the file and considered that the matters being considered on impeachment of the Deputy President of the Republic of Kenya are novel. That is the first issue. The other issue by the judge was that there exists no statutory or subsidiary legislative framework for impeachment of the Deputy President. The learned judge also said that there exists no statutory framework for public hearings and public participation in respect of impeachment of a Deputy President under Article 145. The learned judge also identified another issue, that there have been several bills on public participation and also on the question of impeachment in Parliament, but such bills have never been passed. And then finally, the judge says that the law on these questions has not been settled. It is our submission, therefore, Your Lordship, that based on these issues that have been framed by the judge, this is a proper case for issuance of conservatory orders so as to preserve the substratum of the petitions. Your Lordship, the last issue I want to address is the issue of public participation. Mr. Omari has pointed out the issues which we have in our petitions, and also finally the issue of the Senate. Your Lordship, in our petition, we have questioned the legality of the Senate having taken the position that it was open for them to use the plenary route as opposed to the committee. On that basis, therefore, Your Lordship, these are serious issues that warrants issuance of a conservatory order. Your Lordship, my colleague will conclude. I thank you.
Thank you. Yeah, thank you. Thank you very much. Very briefly, my lord. And I'll just be making some remarks on the two applications for setting aside of the conservatory orders, starting with petition number 565. And looking at the prayers that are sought in that application, my lord, that application is moot. I say so because the substantive prayer number 2, was that pending the inter partes hearing of this application for setting aside, that the orders issued by Justice Chacha Mwita be varied or set aside. My lord, we already passed that stage, and therefore that prayer is not available. Then prayer number 3, that in the alternative, this honorable court be pleased to set aside, vary or discharge the ex parte orders issued on 18th October 2024. My lord, those orders lapsed on Friday, that is the 25th of October 2024. So just to make the court's work easy, there will be no need to consider that application. Having said that, and in view of your previous directions, that this application will be treated as a response to the application for conservatory orders, I would just like to make 2 or 3 remarks with regard to the content of that application, my lord. And I would just like to mention that paragraph 7 of the supporting affidavit sworn by the Solicitor General. Actually, it is in the ground, but then it is reflected in it is in ground number 7, my lord. It says, Article 1 of the Constitution provides that the sovereign power belongs to the people,
and that where there is a conflict between public interest and private interest, the scales of justice to tilt in favor of the public interest. To that, my remark is, the question that is before you is not about a private right. It is a more elevated constitutional question of impeachment of a president or a deputy president. Again, paragraph 8 states that the Constitution does not envisage a vacuum in the office of the deputy president, and as such, it is in the interest of justice that interim orders be stayed, varied, or set aside. My Lord, Article 149 and Article 150 make very clear provisions on the vacancy of the office of the deputy president and how that is treated, even about the vacancy in the office of the president and how all that is dealt with. The Constitution is self-sufficient with regard to vacancy in the executive offices. Just 1 minute. I'd like to make a remark, still to make the court's work easy, in a petition number 15. And my Lord, again, that application is moot. I had to check the one that is on CTS just to be double sure. And the substantive prayers that are sought are prayer number 3. It was an interim order pending inter partes hearing of that application. My Lord, again, we are beyond that stage. We are already at the inter partes stage of the hearing. So the remaining prayer is prayer number 4. And allow me to read it verbatim. That this court be pleased to set aside, review, or otherwise vary grant the ex parte orders issued on 18th October 2024 by Honorable Justice Mwongo Richard Mururu in Kerugoya Constitutional Petition number 15, pending the hearing and determination of the appeal. My Lord, what the National Assembly clearly did not disclose is that after these orders were served on them, they went and filed an appeal. And then filed this application to stay the conservatory order or set it aside pending the determination of the appeal. That has not been disclosed to the parties. It has not been disclosed to the court. So you have no prayer for setting aside of the conservatory order pending the hearing of the petition or pending the hearing of the application for conservatory orders. So again, that application is moot. Turning to the content of that application, in as far as it is a response to the application for conservatory order, firstly, the decision or the subject of the petition before that court was the proceedings before the Senate. Then again, the National Assembly was not necessarily the aggrieved party, but again, they cried louder than the bereaved. Again, if you look at paragraph 6 of the supporting affidavit shown by paragraph 6. The applicant is aggrieved by the order of 18th October 2024 and seeks for the order to be temporarily set aside. Not entirely, my Lord. Temporarily set it aside, pending the hearing of the appeal. My Lord, that is not an appropriate ground because no appeal has been placed before you. At paragraph 7, which is a serious misconception. Yes, my lord.
You had very few minutes. I think you have exhausted them.
Judge, I beg only two. Only two, Judge. Thank you. At paragraph 7, you realize another basis of making this application, which is a very serious misconception. And it says, a presidential system of government works based on the doctrine of collective responsibility. This is a constitutional democracy that we have. The doctrine requires members of the cabinet to work in unison for the sovereign and promote the collective policy agenda. In pure presidential systems, which is not ours, the president retains the discretion to dismiss a member of cabinet who falls short of the expectation. My lord, one of the reasons why we have the current constitution is to prevent this very mischief. So, we can clearly now see the underwriter of all this impeachment process. It is the president who decided a member of the cabinet should not be here. So, this is a process
that is... Objection, that is evidence from the bar.
I'm just picking a paragraph in the supporting affidavit.
Mr. Watuta.
Yes, sir.
Please conclude your remarks.
Very well. Thank you. Yeah, and even more worrying is paragraph 8. Additionally, reinstatement is inconceivable where the member of the cabinet has lost confidence of the sovereign and parliament. My lord, Article 150 sets the ground for impeachment of a deputy president. Lack of confidence is not one of them. Lack of confidence by parliament in the deputy president is not one of the grounds. So we can clearly see the reason why we have the impeachment process. Who is the sovereign? The people. When did the people say we have lost confidence in the deputy president? So all these other grounds, as we will demonstrate at the hearing of the petition, is just a facade, it's just a face to hide the real intention of members of parliament saying we have lost confidence in this particular person. I do not want to go to paragraph 9, but again, those are matters that we'll deal with at the petition stage. But all in all, my lord, you only have two applications to consider, the ones for conservatory orders. The one for setting aside the conservatory orders, my lord, I've made your work easier. Most obliged. Thank you very much.
Thank you.
May it please the court. My name is Dr. Eboso. I'm from Vihiga, and I'd like to...
Dr. Eboso, you'll address us for only 5 minutes, please.
My lord, I will do my best, but I promise I will not repeat anything that has been said. My lord, I'll go straight to the points. One, what is on trial, or what is at stake in the setup of an interim conservatory order? My lord, I'd like to inform the court that what is on trial is a Bill of Rights. Article 38 of the Constitution provides that a person has a right to vie and be elected for office, and if elected, has a right to hold that office. My lord, that is one of the things that is on trial, but I will ignore that for now. What is at stake, because a conservatory order is supposed to preserve the substratum, is a right to a fair trial. My lord, the components of a fair trial include the tribunal that is independent. It includes the process and the outcome. My lord, the outcome includes the remedies that are available by law to the individuals before the court. One of the remedies, the material remedies that the parties before this court are seeking, is reinstatement of Deputy President Rigathi Gachagua to office. Therefore, and I will demonstrate when I talk about the Wajir case at the end, that once a new person assumes that office, that remedy is completely taken off the table. And that means these conservatory orders are actually at the heart of a fair trial. And a fair trial is among the rights under our constitutions that cannot be limited. It is not that a fair trial is absolutely not limitable, but that the state through its action or any person through their deliberate action cannot limit the right to a fair trial. Why do I say this? During a trial, the witnesses may die naturally. COVID may happen and cases are delayed naturally. That is extrinsic and it may affect a fair trial. But the court must never do anything deliberately that would impede a fair trial or that would be imputed as limiting the right to a fair trial. So, my Lord, by lifting this conservatory order, you will be actually limiting the rights of the petitioners to a fair trial by taking away a very material remedy to the remedies that are available to them. I'd like to talk about what is the place of the Bill of Rights under our Constitution and the concept of public interest, because it has come up very much. Now, our Bill of Rights under our Constitution is very fundamental. The Bill of Rights, the chapter on the Bill of Rights, is the only chapter under our Constitution that has its own doctrine of interpretation. And the Bill of Rights is enjoyed individually as per Article 19, is by individuals. It is actually antithetical to the concept of human rights and individual human rights to say that the Bill of Rights will be enjoyed at the behest of a public interest. They are actually specified there expressly, especially to be enjoyed in spite of the public interest. So I feel like the argument that the public interest should be balanced against the Bill of Rights is antithetical to the very concept of the Bill of Rights. The limitations of the Bill of Rights is captured in Article 24, and I would have read the entire article for us to see. But the provisions that it provides is that the Bill of Rights will not be limited except by law, and then only in a manner that is reasonable and justifiable. My Lord, the public interest that has been propounded by at least the response by the Attorney General or the application that by the Attorney General did not disclose the legal basis of that public interest. In fact, it was just general. And it brings me to the question. It reminds me, in 1945, the Supreme Court of the United States was faced with a case about the Anti-Obscenities Act or Anti-Pornography Act. And Justice Stewart, unable to define what pornography is, in his concurring opinion, wrote, "You will know it when you see it." My Lord, that is the kind of public interest that the Attorney General is asking us to use to balance against the Bill of Rights. A public interest that we cannot really tell what it is. My Lord, the public interest that should be able to limit the Bill of Rights must be founded in law. There must be a legal basis for which you're saying this is a public interest. Whatever the Attorney General has propounded, in fact, has not even specified. It must not be vague. It must be very specific so that we can assess its reasonability and whether it can actually be justiciable or it's justified within a democratic society. My Lord, I saw in the response by the National Assembly, the public interest has been a bit defined and has been stated as the fact that we do not have an IEBC. My Lord, that is not a legal question. The other issue was that we cannot stay without a deputy president. My Lord, as had been propounded earlier, kindly allow me 2 minutes. As has been propounded earlier, my Lord, the Constitution allows us not to have a deputy president for at least 60 days, in fact 74 days. So we don't yet have a legal crisis as we speak. We may have a political crisis, but it's not a legal crisis. The absence of an IBC is a political crisis. A political crisis that cannot be brought before the High Court, a court of human rights, as for that to be balanced against human rights. My Lord, the political arms of government are the ones best placed to deal with a political crisis. And tomorrow they can appoint an IEBC if really there is a political crisis. Finally, my Lord, I would like to bring attention to 3 cases by the Supreme Court. The Munya case, Martha Karua case, and Speaker Mate case. Because they kind of explained how conservatory orders ought to be interpreted. And my Lord, what I read from those cases is that a court order through a conservatory order cannot overthrow the constitutional values and constitutional imperatives. A conservatory order by the court fetters discretion, constitutional or statutory discretion, never constitutional obligation. And so, my lord, in the context of this conservatory order, the conservatory order cannot be interpreted in a manner as to freeze time, because one of the things that is considered by all parties in this case is that an impeachment did happen, and it's presumed to have happened lawfully until this court finds that it did not happen lawfully. By that, the constitution is very express that the office will fall vacant, and so that one, however much a court attempts, it cannot constrain an edict of an imperative of the constitution. So the office is vacant as we speak. However, time started running, and the president had 14 days, a discretion of 14 days. The court order can fetter that discretion, and where it seems to the court that the discretion was abused and rushed in order so that you can avoid the rule of law and whatnot, the court can make the conservatory order to be deemed as if the action was done as if that abuse was not there. So that the president still had the 14 days, and so the time is counting. Parliament will still have 60 days. Now, at the end of the 74th day, this court's conservatory order, however much it tries, it cannot extend beyond that. Finally, my lord, I want to talk about the Wajir case because nobody has talked about it, and it was part of the Attorney General's application and response. The Wajir case relates to a governor who was impeached. The deputy governor assumed office and then even nominated a new deputy governor, and then later on the High Court found the impeachment to have been unlawful and reinstated the governor back to office. My lord, there is a distinction, both a constitutional distinction and even a procedural distinction in the two cases. In the Wajir case, the court had issued a conservatory order against the assumption of office, which was defied. But aside from that, because that still is arguable as to whether a conservatory order can do that, there is the question of part of the rule of law and a fair trial is the enforcement, the enforceability of a court order. Now, a court order may be enforced against the deputy governor or the governor of a county. But as per our constitution and as per the holding of BBI in the BBI case, the presidency is absolutely immune. No amount of court order will be issued that will be able to be enforced against it. Because who will enforce the court order declaring the office of president vacant? My lord, it's the political arms of government that can deal with that. And that might be one of the issues that are political questions that the court cannot really address. So, my lord, as far as the office of the deputy president is concerned, such an order cannot come from this court. We cannot allow the conservatory order to be lifted, and then we imagine that we will be able to enforce an order removing Professor Kindiki from office. My lord, thank you very much. I'd like to ask my co-petitioner, I think petitioner number 12.
I wish to make an application under Article 57 of the Constitution. All the members of the society. The owner is now 2:30. Some of us have to eat at 7 intervals. Then also I'm mindful of the court. You have been sitting all the time. You must be now very tired. It has adjourned extremely gentlemen.
I think my lord, those who are angry can leave. Strong ones.
My lord, I would like to support the request, very polite request from Dr. Haminwa. Dr. Haminwa is the #1 longest serving member at the bar. And yours truly is #2. So my lord, breaking for an hour or so is a very appropriate thing to do, and I ask the court.
We want to break by some order.
Yes.
We want to complete the applicant's case. Then we can break.
Okay. We will persevere.
You are the last one.
Yes, my lord.
How much time do you want?
I need 5 minutes, but I would appreciate it if you don't knock, because I have dyslexia, so it will make me start rapping instead of delivering my submissions.
5 minutes, please.
Yes, my lord.
Your name?
My name is Njiru. I am the 12th petitioner in consolidated file E65 of 2024, and together with the 11th co-petitioner, Dr. Eboso, we asked to be enjoined as interested parties in this matter. My Lord, unlike most people in this room, I want to disclose that I have a learning disability or ability called dyslexia, so I ask for time, not to rush me, so I can articulate myself properly. My Lords and my Lady, I would like to ask this court to deem myself and Dr. Eboso being properly on record, for the sole reason that in other courtrooms we have made submissions and been told that we are not properly on record, and would like our submissions to remain on the record. My Lords and my Lady, I only have 5 questions today that I want to task to the judiciary and to the members and to the public and to everybody else. Question number 1, the judiciary on trial. My Lords and my Lady, the only questions you're on trial for in the eyes of the public is a simple one. Is the judiciary truly impervious to the reach of the corrupt and the political class, locally and internationally? If the answer is yes, the Bill of Rights must be respected and upheld. For this, I rely on Article 159(2), justice shall be done to all, irrespective of status. Read together with Article 27(2), which states, equality includes the full and equal enjoyment of all rights and fundamental freedoms. Question number 2, the Constitution on trial. My Lords and my Lady, the second question the public will be asking is, when our Constitution is on trial, because it is no doubt on trial, will the judiciary bend to the insurmountable political pressure, or will jurisprudence, the Constitution, and the rule of law prevail in such adversity? If the answer is yes, then the conservative orders must be stayed. For this, I rely on Article 27. Every person is equal before the law and has the right to equal protection and equal benefits of the law. Question number 3, the laws on trial. My Lords and my Lady, the third question that is important to the public is that once a court clearly states that a right is absolute, as this court did on the 23rd of October 2024, then the public will be interested to see and know if the court will uphold its own directions. If the answer is yes, then this court must respect and uphold its own directives and guarantee all